charge sheet talks of 12 individuals. There's no way they are saying that your clients will continue staying in custody for longer with such.
That a charge sheet can only, that is in the High Court of Nairobi,
Case number?
472 of our case was of the view that what the view to charge an accused person which could lead. It moves on to say confusion in the presentation of the prosecution that the maximum as per this authority of the charges should be 12 in one charge sheet. We have 222, 23. Public servant, just like these public servants. When the state decides to go for their own, they can charge even 1 million counts. And now the second authority, these Kenyans will be relying on, is the Court of Appeal decision.
DPP must decide. It was public knowledge that the DPP was not in office. I can't confirm that now there's a substantive head of the Director of Public Prosecution in office. Let him decide the 12 minimum, maximum charges each person they should proceed. The charge sheet be withdrawn, a proper charge sheet be presented before this court, and they follow the advice of Section 87, they can still prosecute another time. There is a Kenyan who is being told that the state has preferred 223 counts against him. Not even his wife or husband will want to see him or her. It is an embarrassment. The dignity protected by the Constitution is being eroded. The judges of the Court of Appeal saw that jurisprudence long time ago.
State is operating outside the legal instruments and structures that the courts have pronounced themselves on. Charge sheet must not be defective. The charge sheet that needs to be read to the suspects must conform with the law. The moment, Your Honor, you admit this charge sheet and they take plea, their status changes from suspect to accused people. Their jobs, they will be interdicted immediately. Their future hangs on a balance. For flouting a law called theft, called whatever they are being charged, the state equally must follow the law. It cannot be that the state will flout the law and arrest and prosecute these ones who are mere mortals.
Your Honor, we wish to animate our application under Article 49, 1H of the Constitution, which provides succinctly that an arrested person has the right to be released on bond or bail or reasonable conditions pending a charge or trial, unless there are compelling reasons not to be released. And as such, Your Honor, we humbly submit that at this juncture, The question that begs our attention is whether there are compelling reasons not to release the accused persons on bond and or bail. To table and or place material information before the Honorable Court is a duty, as per that decision, Your Honor, that the prosecution must furnish material information to demonstrate compelling reasons. Secondly, Your Honor, you will note that other issues that has been raised are speculative in nature. You've been told, for instance, that because they are the members of the circle, they are in possession of certain critical information. But it
to the affidavit in objection of bail.
The accounts are proper or not tomorrow. We can take a time allocation of, let me say, 10 a.m. tomorrow. I'll not deliver the ruling on admitting on bail before pre-charge, a pre-charge bail, before I deliver a ruling on whether the charges are proper or not. Because for me, I understand it to mean one is predicated on the outcome of a ruling whether the charges are proper or not. So that when assuming I deliver a ruling the charges are not proper, then of course they are then released. I do not need to deal with again the issue of bail, assuming I give that ruling. So that ruling will only take directions from that ruling after deliver a ruling on whether the charges are proper or not. And that ruling is coming tomorrow at 10.
Fortunately enough, the advocates on record for the suspects were very keen with respect to the charge sheet that was presented in court. It contained a record of 223 counts. So very fast we raised a preliminary objection on the legality or the lawfulness of that particular charge sheet, and the court was gracious enough to give us opportunity to submit on that particular issue. So as we speak, the suspects have not taken plea. They will only take plea once the court makes a determination on the lawfulness or unlawfulness of that particular charge sheet. So the court has pronounced itself that tomorrow at 10 a.m. it will make that particular decision. Then going by the decision, they will either take plea or the prosecution will be sent back to amend the charge sheet and bring the charge sheet back to court once it has met the legal threshold. So you are a battery of lawyers actually, and
perhaps abuse of judicial independence, abuse of the office of the DPP, where you put high premium on pretrial detention. That means you arrest on a Friday, detain for 48 hours, bring him to court, seek denial on bail, then during the process of 6 months, 1 year down the line, you withdraw the case. So my appeal to the office of the DPP, my appeal to the investigators, please do your work. Please avoid using the criminal justice system maliciously to pursue pain, to pursue malice, and do your work in that to avoid the issue of pretrial detention and focus on the actual trial. So my appeal to the new holder of that office, perhaps to do things better than the previous holder, where there was an abuse of the system, pretrial detention, and flying against the provisions of Article 49 of the Constitution of Kenya 2010. So that's my appeal. My appeal as the legal practitioners of this country.
Our main areas of concern is the jurisdiction of the court. This court was formed to deal with the terrorism issues. We are a bit concerned that the state has taken it upon yourself to try and bring charges upon members of their own, in this court. They have not committed any terrorism-related charge. We have a feeling that this charge should be presented at Milimani law courts. However, we are going to be given directions tomorrow on whether the charges have been rightly put in this court, and our appeal to the prosecution office is that they should not be in a hurry to mostly present officers, security officers to the courts in this country. Security officers play a very important role in this court, and therefore there's a likelihood that the same is going to make officers fearful, even in the performance of their duties.
So, procedurally, and in my own view, it is a waste of time. The law as it is, only 12 counts, charges, can be held in a charge sheet. Number two, I also raised another issue. Do we need to destroy the national intelligence services by bringing these people to court? Is there any other way they could have resolved this matter? Are we likely to bring national security matters to open court? My advice is that the instructions I have, I will be writing a letter to the Director of Public Prosecution today, who has been sworn in today, to review these charges, because they are going to be a security fiasco. It is going to be, imagine us calling upon the board, bringing upon top managers, top officers of NIS to testify here. It is not one of the best. I am sure the decision to charge was done before the new Director of Public Prosecution came in. We will write to him today that let him recall this matter and consider alternative ways of resolving this matter. We have also raised the question, is Njiwa Sacco a registered deposit taker? No. So, if Njiwa Sacco is not licensed by SASRA to take deposits, how are they having tellers? Were they operating outside the law? An illegality, an illegal entity in terms of this case called Njiwa Sacco cannot pretend to bring people here to court. Where is the CEO? Where is the board? Where are the top managers? Those issues are the issues that we'll be raising to the new Director of Public Prosecution, and I hope by tomorrow when we come here, the DPP will recall the file to look at it afresh.